All rise.
Further hearing in the appeal, Braze Timber Products Limited against Majesty Revenue and Customs.
Yes, Mr. Sherry.
Over the adjournment last night, we prepared some written summary submissions to expedite this morning's hearing. I don't know whether your Lordship had the opportunity to...
Well, we haven't just seen it this very moment.
But they were delivered first thing. But it might assist, my Lord, if you were to just very quickly read those submissions, and then I can make one or two further points.
Well, there's quite a lot to assimilate. I'm not sure that it's very satisfactory for us to sit here reading for the next half hour. Can you just take us very quickly through it and
yes,
see what it is? It's
So the page 1 and 2 is on the company law points which you asked for the reading last night, and it summarises the propositions that class rights may be personal to a particular holder, point 1. They may be contained in the shareholders' agreement, point 2. Point 3, they can be set out elsewhere than in the articles. Point 4, that it's usual to have power in the articles, and we have it here, which sanctions, with the sanction of a general meeting, permits rights being attached to classes of shares, and whether they're preferred, deferred, or other special rights. Point 5, that such rights may be created by the terms of issue of shares, and that relies on the couple of the textbooks, and of course that's the most important one to our case. And point 6, that breach of an agreement between shareholders where the breach is by the majority shareholder, and it doesn't necessarily have to be by all the other shareholders, if leading to unfairness, may give rise to a remedy under section 459 and of the Companies Act 1985, which was the remedy provision in force at the time that we're concerned with, and I've set out there the passages in the speech of Lord Hoffman upon which we rely in particular in support of that proposition.
and the last paragraph of 6, you're saying that if there was to be a breach, that could influence the price Jewsons would be prepared to pay to Mr. G when buying the company. I'm not sure I understand that.
No, what I'm saying there, my Lord, is that if 50% of the shares have been sold by shareholders other than Mr. Gibson, under the shareholders' agreement, that would have triggered clause 4 the provisions of clause 4.
Yeah.
If those provisions had not been honoured, then a breach on this basis arguably would be within the scope of unfair conduct, for which section 459 is a potential remedy. This will be a consideration which any reasonable purchaser would take into account. The purchaser of the whole company, or indeed just a 50% stake. So a purchaser such as Jewsons, who wanted to take over the company, would be mad not to take account of the possibility that if they did so in a way, in circumstances where the shareholders' agreement was not honoured, then Mr. Gibson might have had, as a result, and I put it no higher than that, a claim under 459, and any prospective purchaser simply would not proceed on the basis of accepting that risk.
You're not suggesting, are you, that they would pay more for the company overall?
No, I'm not at all.
So this is a question of distribution of the price?
Yes.
Right, I follow.
But, if you want to buy the company and you know that this agreement is in place,
Yes.
and you can work out that maybe a breach of it might end up on the company's doorstep,
Yes.
so the doorstep of the thing you're actually buying, this is something which, even if it's not actually conduct which falls within 459, the possibility that it might be is enough to make you follow a course of conduct which says, well, I'm simply not going to have any of that. If I'm buying the company, I want all these things cleaned up. And that would be normal in a corporate takeover. You don't want to buy loose ends.
Yes, I follow.
So, my Lord, all of these submissions on company law back up that point at a practical level. Whether or not they're right, the fact that they are even tenable, that the comments are in the textbooks, is enough for a purchaser to think, well, I've got to take cognizance of it. I can't risk this agreement not being honoured. On page 3, my Lord, the company's articles. The company's articles incorporate Table A. Article 2 of Table A is in the form which empowers, is set out there at paragraph 3, subject to the Act and without prejudice to any rights attached to any existing shares, any share may be issued with such rights or restrictions as the company may by ordinary resolution determine. And it's our proposition, my Lord, that in approving the subscription agreement, the company did so determine that the shares issued to Mr. Gibson should have the rights and restrictions set out in that agreement.
Looking back at 2, the normal example would be that which one sees in the cases that you referred us to yesterday, where there's, in a private company, there's a restriction on transfer. Is that not right? And therefore, the purchaser will take the shares subject to that restriction.
Well, my Lord, that is a common one, but the provision also refers to rights, and it's plain from both Cumbrian newspapers and Harman that those rights might include the right to form part of a quorum at a general meeting,
yes,
to a named shareholder, very personal, and in the Cumbrian case, a variety of rights accruing to the named shareholder.
So there could be rights that are entirely personal, or there could be rights which would transmit to the purchaser.
Indeed, my Lord. And for present purposes, it's enough that those decisions are reported, because it goes back to the point we've just been talking about. The purchaser, if their advisors investigated the matter, would say, well, it may be that Cumbrian might be overturned one day. It may be that Harman may be overturned. But for the time being, we must proceed on the basis that they're good law.
The problem in most of the cases, the estate duty cases, where, as I understood it, was that there was an assumed transfer on death. And it was a rather awkward thing to face up to, where there was a restriction on transfer. And so the assumed transfer takes place, but what is transferred is a share subject to the restriction, which would have prevented the transfer in real life had somebody been asking permission to do that. So I think I can follow that, but how that applies in this case is at the moment eluding me, because it doesn't take you the distance you need to go in this case.
That principle, I say, applies equally to things which can't be transferred, but we say there are things here which can, but nevertheless, even if they can't, for the reasons given by Lord Roche and Crossman, that you have to face up to this difficulty. How you do it is a valuation exercise problem, which Lord Roche cites Mr. Justice Russell, as he was in Recastle, saying you've got to face up to it and it's got to be done, whatever the difficulties. And Alexander, we submit, is an illustration of the approach to that kind of problem. It's not identical to this, I fully accept, but it comes part of the distance in that the incident that was causing the difficulty in Alexander was something which on any actual transfer would in fact disappear. So it has that in common with our circumstances. And nevertheless, its effect on the value at the point of valuation still had to be taken into account. In the subscription agreement, my lord,
here you have to assume that somebody wants to buy these particular shares. Shares, isn't that right?
you have to, yes.
Because there could be plenty. Let's say somebody merely wanted to buy 5% shares.
Yes.
Then you could buy them much cheaper elsewhere. So you must be somebody.
But what you have to assume, my lord, is that the buyer of these shares would step into Mr. Gibson's shoes.
Yes, but he has to want to do so.
Yes.
He has to want to pay enough. In other words, he doesn't just want 5%. He wants to buy 5% with
on these terms, on the terms that these shares were issued.
Yes.
Yeah.
But there is a difference, isn't there? Because in the estate duty cases, there is a deemed transfer, not an actual one. There isn't an actual sale. Whereas in this case, we're dealing with an actual event.
Well, there is an actual event in parallel to the exercise that the court has to carry out.
Well, it's a chargeable event, which is an event that actually takes place. And one doesn't have to deem anything about the chargeable event other than the exercise which is set out in Chapter 3D. The formula tells you what you do.
But that still requires one to say what is the market value.
Yes, of course it does.
And that still leaves the problem as to whether or not these shares have a different market value at that point of valuation because of the rights which at that point are being fulfilled. It goes back to the point I've already made. Would Jewson be prepared to take on this company paying Mr. Gibson only a pro rata 5%? Would any reasonable purchaser do that? No, because of the existence of this agreement, even if it's not attached to the shares, and even if it doesn't run with the shares. But, my lord, if I may take you to the subscription agreement.
Yeah.
And my submissions are set out in writing. So
Yes.
That will assist us at page 169, page 170. In Appendix 2. We find first recital B in the middle of the page. The company has agreed to issue such shares to him on the terms and conditions set out. So it's express that these are the terms and conditions of the share issue. And then turning to page 175, the definition of Mr. Gibson's shares means the ordinary shares to be subscribed by Mr. Gibson pursuant to 2.1.2. So it's not the shares held by him at any given time. So this definition applies to these shares, whoever's hands they may be in. Then, if one looks at the terms on page 179,
So just to be sure that I followed that, you're saying subscribed as opposed to held is suggesting that a purchaser would be interested in this provision as well as him.
he may well be, my lord. And we'll come on to look at some examples of that in a second. So, my Lord, on page 178, at the foot of the page are the provisions about the termination of the service contract and what happens there. And you see that the obligation imposed is that the shareholders shall procure that the company shall purchase Mr. Gibson's shares. So not shares held by Mr. Gibson, but this is the defined term. And the next clause is interesting, because the first clause effectively applies in circumstances of bad leaving or a voluntary resignation by Mr. Gibson. But the next one is any other circumstances than 3.2.122. And if you look at 3.2.3 over the page, just briefly, it says, in the event that the service agreement is terminated in circumstances not described in the two preceding clauses, including, without limitation, the death or incapacity of Mr. Gibson. So here's him dying. Then you go back to the previous page to find out what happens. And 3.1.2 says that Mr. Gibson shall sell, and the purchasers shall procure that the company shall purchase all save one of Mr. Gibson's shares. Now that's important, because that's what the agreement calls the option share. And the significance of that is that the payout is dictated by the formula on the next page for the all bar one. But if there is a disposal of the business or a disposal of the controlling interest in the company in the next 18 months, then the provisions of clause 5 kick in. These are non-embarrassment clauses. In effect, they provide for further payment. So that Mr. Gibson may have resigned of his own volition, or he may have been forced out, or he may have died. All the shares bar one have been bought in according to the formula on page 179, whichever one it is. But that one share can still qualify, and it may be in the hands of his estate. It may be in, as we'll see in a moment, it may be in the hands of a relative. There are a number of people whose hands it may be in, but it would devolve on death. And if death was the event which triggered that, then it would have to devolve on death. So there are rights here which survive certainly death, and that takes us bang slap into all the authorities, all the estate duty authorities. There are other indications in the agreement which have the similar import. So if one looks at the warranty under clause 7, this is a general warranty which Mr. Gibson gives, that he will not, in the second line of 7.1, he will not sell, transfer, pledge, or otherwise in any way alienate any of Mr. Gibson's shares. That is, the shares acquired on these terms. But then, in 7.3, we see the sanction. In the event of a breach of the foregoing warranty, it is agreed that the service contract and Mr. Gibson's appointments within the group may be terminated by the company forthwith and without penalty or liability, etc. Then, the crucial sentence, the foregoing shall be the sole rights or remedies of the shareholders in the company arising from such a breach. The consequence of that provision is that even if he disposes of some of the shares, he can get the sack, but otherwise the rights survive, attached to the shares he's disposed of. And we see that that's the case because of the way in which the provisions of clause 3 and clause 4 apply. So if one goes to page 181, for example.
So this is the proposition at the bottom, page 4 of your note, is it?
It is, my lord.
You say some of the shares could be alienated and still benefit from the provisions of clauses 3 and 4, which he could enforce.
Which he could enforce if he still held some shares. He would still be a party to this agreement on the basis of my earlier submissions. So at 4.1, the obligation is to procure that the company or the purchaser, in terms of the share disposal, shall purchase Mr. Gibson's shares. That is, the shares subject to the agreement, not necessarily the shares held by him.
Yes.
And it's important to note at this point, my Lord, that although the articles that were adopted have the usual restriction on registration of transfers, there is an exception to that in respect of a variety of transfers which Article 11 permits. So if I may briefly take you to page 217. So these are the articles which were adopted at the same meeting as the subscription agreement, and in paragraph 11A you have the traditional director's discretion, and then in B and you see A is expressed to be other than a transfer pursuant to B, and B, subject to D, the directors shall register the transfer of any ordinary share, and then essentially it's within your family or to trustees. So it is certainly possible to transmit these shares without even the usual restrictions of the director's discretion preventing transmission, for the obligations under the shareholders' agreement to continue in respect of those shares. The obligation is to buy those shares. In those circumstances, my Lord, if this agreement is, as I say, part of the terms of the issue of those shares, I would submit that it follows that the holder would be able to enforce its terms, at least against the company.
Can I be sure I grasp this? 11B is referring to any ordinary share, any of them.
Indeed.
But are you saying that that has implications for Mr. Gibson's shares, and that if there is a transfer, that carries with it the rights?
Well, what I'm saying, my Lord, is that it's plain from 11B that Mr. Gibson could transfer some of his shares as of right.
Yes.
And then the consequences of that are to be found in the subscription agreement. The consequences are, under paragraph 7, he will be in breach of his warranty.
Yes.
But the only negative consequence flowing from that is that he can be sacked. That's 7.3. It follows that the other benefits of the agreement are still in place. In effect, the benefits of the agreement have survived transfer of shares, and if I'm right that the agreement contains the terms of issue of the shares and so attaches to the shares, others would have the right to enforce against the company.
This is an extraordinary argument. It's not been deployed at any stage before in these proceedings, has it? It has in a much more limited way, my Lord, but not in the detail in which I'm presenting it now. I mean, we don't find any hint of it in any of the decisions or the judgments below.
Save for the observations made by Lord Osborne as to the significance of the percentage of shareholders who are but it's an argument that puts a huge amount of weight on this sentence in 7.3, that shall be the sole rights or remedies of the shareholders and the companies arising from such breach. But
that surely does not exclude the practical consequence that if Mr. Gibson has parted with the shares, he can no longer sell them under Clause 3.
But it's not he who's selling them under Clause 3. That's the point of the terminology of the drafting of Clause 3 and 4. Well, there's an obligation for him to sell if he's got them. I fully accept that. But the corresponding obligation is that the company shall purchase, and that's, I would submit...
Well, it's only an obligation for the company to purchase. If he's got them to sell, I simply can't see this.
Well, my lord, you have the submission. And in any event, quite apart from the implications of the Clause 7 point, there is the effect of Clause 3.2.3, which envisages that the rights could survive and will survive his death. At the highest, I say that Clause 7, read in the way in which I submit it should be, is consistent with Clause 3.
Well, I must say, following Lord Walker's comments, I would have expected some notice of these points to be in your written case. I mean, I'm just looking ahead, there's an awful lot of here seems to be just injecting into your argument things that should have been in the written case. Mr. Johnson should have had notice of long ago.
My Lord, I can only apologise for this not being set out in more detail earlier. The thought process of trying to analyse the relationships, firstly, of all the provisions in Part 7 in the detail which has been required, and the more one looks at agreements like this, the more one gets more familiar with them and understands them better. But
well,
I can only apologise for that.
I think I made the point yesterday. You were before the special commissioners, and it's very surprising that your thought process hasn't kicked in until as recently as this.
One always hones and develops one's thoughts, my Lord.
Well, let's just see what else you've got here very quickly. We've got observations on the share sale agreement.
Which are very simply that the allocation of the consideration in the share sale agreement is set out very clearly in the schedule. There is a provision which the Special Commissioner drew particular attention to on page 237. In clause 3.1.1, in the second sentence, for the avoidance of doubt, the allocation of the consideration set out in this clause 3.1 shall not be binding on the purchaser or the warrantors in connection with any warranty claim. The Special Commissioner concluded that this provision meant that the allocation of the consideration wasn't binding on the purchaser at all. But it's clear that this sentence is only in connection with the warranty claim, and that makes sense because each of the warrantors is jointly and severally liable on the warranties. And so the purchaser, because of the way the warranties are constructed, if it weren't for this provision, the purchaser will be restricted to recovering from the warrantors by reference to the allocated consideration. So for that purpose, Schedule 1, setting out the consideration, is not binding. By implication, it is therefore binding for other purposes.
But I mean, under 3.2.1, providing the purchaser pays over the 5 million odds to the vendor solicitors, he gets a discharge for the whole thing.
Well yes, but that's because the vendor solicitors are acting as agents for the vendors.
Yes. But
so he's paid everything to the agents for that group of people.
Yes.
And so it's then expressly provided he gets a discharge. Now, as a practical matter, that's mechanics. If he didn't get that discharge, he'd be obliged to find out what the vendor's solicitors had done with the money, and that's wholly impractical. This is a mechanical provision, not a substantive one.
I'm not sure I understand that. I would have thought that it's very important, and the whole mechanism, it is perfectly true, it's mechanism, but it's, you can see there's a retention element, but the whole thing is transmitted in a package, an undivided package to the vendor solicitors, and the retention is undivided. It's just a percentage amount of the total price.
Indeed, my lord. That is the stage at which the purchaser has paid the agents for all of the vendors, who have appointed the one agent to act for all of them. So he has no power to see further than that.
3.4, how does that work?
That's the provision which actually says explicitly that the consideration is to be divided in accordance with Schedule 1.
Yes, I have read that. I just want to know how it works. I mean, given 3.2.1 and 3.4, how do they work together?
Well, my lord, the consequence is that so far as the purchaser is concerned, he's assured that the vendor's entitlement is in accordance with Schedule 1 because the vendor's entitlement is set out in 3.4 and the schedule. So by this means, he knows that having handed the money over under 3.2.1, he has discharged the obligation to pay, for example, Mr. Gibson, the consideration which is set beside his name in the schedule. And so Mr. Gibson, as a party to this agreement, has accepted that.
No, I think I should warn you that I said yesterday you're going to have to finish by about 11:30, and it's just after 11, so time is running against you.
So, my lord, if you turn to page 7 of my written submission, I set out there various observations on the Special Commissioner's decisions, some of which echo those of Lord Osborne, the majority of which echo those of Lord Osborne and Lord Kingarth, so I won't take you to those, and I don't think the others are that significant. As to the decision of the Court of Session on page 8, we have set out observations in our written case, and the only observation here I would particularly like to take your lordship to is the third one. At paragraph 90, Lord Mackay concluded by analysing the nature of the receipt in the hands of Mr. Gibson. An amount calculated in terms of clause 4.2.2 of the subscription agreement will be required to be paid to Mr. G before Jewsons would acquire a beneficial interest in the whole share capital of the company. In my opinion, payment of that amount was the equivalent to a settlement of a debt falling due by the company to Mr. G on the completion of the shares disposal. In my opinion, it was a debt that fell due to Mr. G in terms of clause 4.2.1 of the subscription agreement, rather than one rising out of the rights that attached to and ran with his shares when he ceased to enjoy beneficial ownership. So it's the equivalent of a debt. It's clear that Lord Mackay thought that the right to the overage arose not from the disposal of the shares as such, but attributable to the subscription agreement and was equivalent to a debt. If that's correct, two alternative submissions follow. Firstly, the amount in respect to the overage was not in substance consideration for the disposal of the shares at all. And secondly, if the total consideration is partly in discharge of that debt and in substance represents an interest in the proceeds of the other shareholders' share disposal, it represents an employment-related security. That's the alternative point. I will address you, my lord, on permission in a moment. Turning then to page 9, on the structure of the Act, my lord, these observations largely summarise and repeat the submissions that I made yesterday. But there are 2 points to note. One, you have an example, which is amongst the papers that were handed up. I leave that with you, and I hope it's of assistance in understanding how the provisions work. The second observation I would make here is that whether or not one gets taxed at the beginning or the end was the way in which I put the argument yesterday. And Lord Walker asked me the question, was this fair or equitable? The observation I would make is that in employment matters, when one receives something from the employer, that is generally the point of taxation on the money's worth. That's the general principle under what used to be called Schedule E, now Section 62 of ITPA. So that the point of taxation when you receive a share, for example, is when you receive it. So there have to be statutory rules to take it to somewhere else. Mm-hmm. And, for example, in relation to options, those statutory rules are spelled out very clearly in Chapter 5 of Part 7. In relation to restricted securities and convertible securities, they're laid out very clearly in Chapters 2 and 3.
And these are what referred to as chargeable events.
In those chapters, yes. Indeed, my Lord. So that those specific rules aside, the general principle is that one gets taxed at the beginning. Now, if one accepts that Part 7 treats collateral rights and interests as part of the equation that is being taxed, and is part of market value, then to tax them at the end under 3D rather than under 3C at the beginning would be a departure from that general scheme. And it would also have the consequence in relation to Chapter 2, restricted securities, and most securities of this sort, I would submit, are likely to have a limited restriction on alienation, whilst the employees in his office or for a period of 3 years or something. If the employee elects out of Chapter 2, under the provisions we saw in 431 yesterday, he pays tax on the notional unrestricted market value. So on the whole value of the share, even though under general principle he's actually got something which is worth less.
Well, I don't want to go over the detail here, but the chargeable event in the example you gave, I thought was a removal of the restriction.
Indeed, or possibly a sale is also a chargeable event.
But that's why I don't fully understand your point that it's all taxed at the very beginning.
But that's if you make an election under 431, you then pay tax on the unrestricted market value at that stage, and the value attaching to the lifting of the restriction or its expiry doesn't get taxed at the later stage. Under 431.
Anyway, you're taking up time and going into a bit of detail which we really don't need.
The point is one of consistency.
Yes. And the attached example to which you refer at the bottom of page 9 is to be found where?
It was handed up. I think you should have it underneath, my Lord.
Is this it here?
You've got the BVCA memorandum, which
yes.
you asked for yesterday.
Oh, the example, yes, I'm so sorry.
And then there's an example.
Yeah, thank you.
And I leave that with you, my Lord. There's nothing particularly contentious about it. I hope it's helpful. But having the final submission I would like to make on consistency is that if the Crown are right, then rights which are contained in a collateral agreement give rise to a charge under Chapter 3D at the end. But if those rights, and they may be identical rights, maybe, if those rights are contained in the articles and so are part of, or intrinsic to the asset, then they wouldn't give rise to a charge under Chapter 3D. And that result, we say, is completely inconsistent, not only with the construction of the provisions that we looked at yesterday, but with the scheme behind them. Because the scheme, as illustrated by the use of those very wide words in Chapters 2 and 3, contract, arrangement, etc., is to treat all things relating to the security in the same way.
Yes.
My Lord, page 10, I finish off summarising the submissions I made yesterday, paragraph 7 is the point on section 18 of the TCGA, and then I summarised the points that I took you through yesterday in relation to the estate duty cases. There's nothing, I believe, new there, and that takes me to page 11. This is the alternative point. Our submissions on the alternative point are set out in the written case, and I referred to them in passing as we went through the statutory provisions yesterday. As to permission, my Lord, if our other submissions on the main issue are unsuccessful, then it's submitted it will be inappropriate to conclude without considering this point, which, if accepted, would provide a means of recognising what it was that Mr. Gibson acquired and paid for when he entered into the subscription agreement and acquired his shares for the price there specified. And so far as this argument relies on section 421 and is a new point, we say that, paraphrasing Lord Oliver in Brady and Brady, it would be entirely unsatisfactory if, excluding the point, resulted in what is in effect, and this is the paraphrase, the taxation of a receipt as income, when in fact there is a conclusive answer in the law to that contention. In Brady and Brady, the phrase in the gap was a declaration of illegality. Here the Crown says that fresh evidence would be needed. We say that's not right, and we say that's not right because of the terms of issue. Terms of the issue, which can be found in the statement, in the core volume, or if you have it loose, my Lord, it's at the end of the statement, and it's in exactly the same terms as it was before the Special Commissioner. It's whether the disposal by Mr. Gibson was a disposal giving rise to a charge to tax on employment income in the terms of section 446Y, and upon what basis the market value of those shares is to be determined for the purposes of 446Y. And it's kind of the wrong way round. The second question arises first, but we say that is an issue of principle, which raises the points of statutory construction we've been looking at.
Well, the way I don't think Mr. Johnson would dispute the fact that the issue is so broadly framed that it could be said to be within it, but the point he's making in paragraph 36 is the introduction of an argument, and it's entirely new. That's his point, paragraph 36. An argument that was not raised at any stage below.
It is a new argument, my Lord, but it is insofar as the question always an issue was how do we ascertain value and not what is the value, because it was deliberately framed in that way so that if the answer given by the Special Commissioners or indeed by your Lordships was required expert evidence, then the matter could either be agreed between the parties or go back to the Special Commissioner. So the point of the proceedings was to get the principle resolved. And the Special Commissioner's methodology meant that he could tell us precisely what the number was, but that wasn't a foregone conclusion. And that's why the question is framed in this way.
Well, look at the second sentence in paragraph 37. He's saying whether such non-assignable rights, now that's picking up what I think is clause 7 in the agreement, isn't it?
Indeed, my Lord.
Were granted to G under the subscription agreement could be and were on their own turned to account in the market, and for what is a question of fact. Now, from time to time you've been referring to the way in which the thing might have been operated.
Indeed.
But the question is, was that actually what happened? Because we're dealing with reality here. We're dealing with an actual chargeable event and things that actually occurred.
Indeed. But the facts in relation to that question are in the Special Commissioner's decision and are known.
Well, they didn't consider these non-assignable rights being turned to account on their own in the market.
Well, that's true, my Lord, but what was turned to account and the reasons for it. Indeed, the Special Commissioner says that the amount Mr Gibson received was more than it otherwise would have been because of the shareholders' agreement. The point is so obvious that Lord Mackay actually went so far as to say the difference between the pro rata amount and the amount actually received was equivalent to a debt from the other shareholders. This is not a difficult issue, but if there is a dispute as to the precise amount, my lord, that the answer to the question raises, then that, I submit, is a proper occasion for this to be sent back for additional findings, or with liberty for the parties to apply if necessary. But if the answer is well, here's the method and it can be applied very simply, then no difficulty arises. And we submit that's the case here. And certainly there's no new evidence needed to resolve the issue as to the correct application of the principle where one has collateral rights such as this, which, in the words of Lord Mackay, give rise to an amount equivalent to a debt from the company. And for those reasons, my lord, we invite the court to give permission for this point to be raised. And if the court grants permission, you have our submissions on it in the written case.
Just to be quite sure on timing, just to be quite sure I've understood, on page 12 of 12, the last point on paragraph 7, little 4, you say that the point was raised in correspondence in July, but that's the first time it was raised.
Indeed, my lord. As a separate issue, although, as we said then, we say that in the context of the original dispute, it is a matter of, it's an incident of the statutory construction of Part 7. So, in a sense, although the specific legal argument wasn't raised earlier, it's within the scope of the argument which has been taking place throughout. There is certainly no mention of this provision in our skeletons below or anything of that.
It obviously follows from that when the revenue were seeking to obtain information for the making of the assessment, they didn't raise this point at all.
No, they didn't, my lord. That's absolutely true. All of this, my lord, I submit, has to be viewed in the context of the revenue's statements in the frequently asked questions. That actually this just doesn't arise.
What do you mean by that? Sorry, I haven't quite followed it.
The revenue say in their frequently asked questions that whether or not rights are in a collateral agreement or in a principal agreement doesn't make a difference. They all affect market value. So in this case, that is part of the background to the way in which it was argued and focused below. By way of, if you like, explanation as to why this point wasn't raised earlier.
Yes.
My lord, if there is anything else I can help you on.
Well, I'd just like to ask one question, because I've lost the shape of much of this. What do you say is the paradigm case at which Chapter 3D is aimed?
A circumstance where...
Well, just give me the facts, very simply, in this sort of area to do with an issue of shares where it's aimed.
An employee holds employment-related securities. He's realised a loss, and the employer says to him, You paid 100 for this, they're only worth 50 now when you sold them. Why not sell them to me for 100? A stop loss provision. Coming in, not necessarily at the beginning, but on disposal. So something that isn't pre-agreed.
Stop loss. Anything else?
Sorry, my lord, you asked the paradigm case.
Yeah.
That's it.
Any other illustration? Common case.
A common case. Well, the 3D doesn't apply commonly. It's very rare.
All right. Any other example of where it might apply?
That's the paradigm case, my lord. On the spur of the moment, I can't think of others. They might involve swapping one security for another, and that does happen. But I would say any transaction with the employer, which was not pre-contracted at the time the securities were acquired, certainly. So any bounteous transaction with the employer which takes place at the point of disposal.
Cool. Thank you very much.
Thank you, Lord.
Mr. James, do you wish to add anything?
No, my lord, other than just on the very last point about 3D.
Yes.
If I may. In a sense, the way to think about it, I think, which might be helpful, is that 3D is there really to catch further gratuity coming from the employer, and the stop-loss arrangement is that sort of classic. So if your shares go down from perhaps the value you gave, we'll make up the difference. That's what 3D was introduced to do, to sort of enable the employee to catch up. So gratuity, there's further gratuity, if you like, from the employer, which requires taxation. Whereas if what's happening on the occasion of sale is merely the fruition of rights that were there from the outset, which have, in the normal course and under the scheme of the provisions, have been taxed at the outset, there's no reason for 3D to kick in. And the present case is a classic of that. It was an actual sale in the market of something which he'd had from the outset from his employer, which he duly realised. So there's no reason for 3D to kick in at that point. There's no further gratuity from the employer that requires taxation. It's simply the fruition of rights, which are either taxed at the outset or not at all.
But if the stop-loss agreement was agreed at the outset?
Well, that also would be covered, I think, by 3D, arguably. But 3D is a residual provision. It is a residual provision. If tax has been paid in respect of those rights at the outset, there's nothing for 3D to buy from.
How do you find that in the language of 3D itself? Because 446X is quite generally worded, which is why I mean, you obviously have to accept that.
That's why it's so important to put it into the context of the provisions. Although it's a difficult and laborious process to piece together Part 7. It's only when you put the pieces together that you see how 3D is intended to play out. And that's why it is important to factor it into chapters 2 and 3 and see how it works. Because the language is very general with 3D. So on its face is almost unlimited, and as applied by the revenue in this case, is a capricious result.
And there's nothing you can point to in the earlier parts, the introduction, the general section, which qualifies 446X. You have to look at the whole lot, you say, to get the context, is that right?
You do, certainly, well, Absolutely. I mean, what you've got in Chapter 1 is a single definition of market value, which applies throughout the That must be consistent and takes into account personal restrictions. And applying understanding market value in that way, that is your limitation on 3D. But these shares simply weren't being sold for more than market value because that market value took into account the rights that were there from the outset, whether they were personal or not.
Thank you very much. Yes, Mr. Johnson.
If I can take the principal argument first, the correct approach to market value, which depends on the authorities that the Lord referred yesterday. Rather than take up time with looking at them, if I could simply sketch out what in my submission are the main propositions that relate to that. Clearly, the Court is concerned here with the proper construction of market value in a particular section, Section 446. Note that by virtue of Section 421, market value has the same meaning as in the capital gains tax legislation.
So it's 446Z1, which defines market value in the same way as we see all the way through and takes us right back to that.
Oh, yes. That's it, yes. And so while there may not be any authority on Section 446X itself, the proper construction of market value, as I think was discussed with Lord Walker yesterday, is one that goes back a long way. It goes back for the purposes of capital gains tax to 1965. And in relation to estates, it's a matter of even longer established valuation practice going back more than a century. And as my lords have seen, the leading cases on the question of market value are, I think it's probably common ground to say, firstly, the Crossman case, secondly, Lionel, thirdly, Fox, and fourthly, perhaps slightly less relevant on these particular facts, the Duke of Buccleuch's case. And what I'd like to do before I look at the agreement is simply draw some propositions from those cases, most of which I think would be uncontentious. So the first of those is that the first step in evaluation is to identify the precise property to be valued. We can see that in Crossman when one looks to see what rights are inherent in the share. And that's at pages 41, 49 to 50. And I would like to take my lords to Crossman in a moment for some other points. We can also see it in Fox at 371. And of course it's inherent in the whole discussion in the Duke of Buccleuch's case about whether one should value a large estate as a single unit or as a number of smaller entities.
I think the point there was, do you take it on a single day, or can you spread it out over the period as you would do in real life? Is that it?
Yes, that's right.
And that wasn't permitted because it had to be, there was a statutory date for the carrying out of the transaction.
Yes, exactly, yes. So that all of those support, at any rate, the proposition, which I imagine is uncontentious, that we need first of all to identify what we're valuing. So for purposes of this case, the question is, are we valuing the shares, or are we valuing the shares with the benefit of rights given to Mr. Gibson under the agreement? The second, again, I think non-contentious point is that the statutory test is based on a notional sale of that property, the property that's been identified, by a hypothetical vendor to a hypothetical purchaser. And that's simply the Crossman case. Thirdly, the notional sale is merely a means of, or machinery, as some of the cases put it, simply a means of or machinery for ascertaining value, to identify what a purchaser in the open market might reasonably be expected to pay. Again, that's established by Crossman's case. Fourthly, the hypothetical sale takes place in the real world, in the sense that the facts are the real facts, but the vendor and the purchaser are hypothetical.
So you strike your value by looking to, I mean, if you assume it's a piece of land, at comparable properties, and you can look at the real world to establish that. And the shares, again, you're looking to the real world to find out what the value is. Is that right?
I think that proposition I take from Lord Hoffman in the Fox case at page 372. But I think what the Lord says, that I would assume is what his Lordship had in mind. That one is looking at the real facts in order to understand the market, but one is then applying those facts in relation to a hypothetical vendor and a hypothetical purchaser.
Well, that's certainly true in valuation for rating. One takes actual transactions, but it's a hypothetical lease at market value which is being looked at.
Yes.
These cases all make it plain that you take a notional or hypothetical sale between notional or hypothetical vendors and purchasers, even when you've got an actual real sale.
Well, yes, exactly so.
Some of them deal with real sales, but they then say, okay, forget the real sale, we'll deal with it on a notional basis. Okay, yeah.
Yes.
That wouldn't always be so. In capital gains tax, you would tax simply what happened, presumably. Is that right? I mean, but in this case, you've got a formula which takes you to market value.
Yes.
To that extent, it's artificial. And in estate duty, it had to be that way because there wasn't actually a sale on death, but you assume it for the purposes of the tax.
Yes. Yes, well, I perfectly agree with that. I think the point here, because we have the statutory formula and because we have shares, as in Crossman's case, that have inherent restrictions on them, one needs to conduct a hypothetical exercise, otherwise the shares are worth little or nothing if they can never be alienated.
Yes.
And so that, just pursuing this point slightly further, by reference to what Fox's and Lionel's case tell us, in my submission, all we can take from those is that the hypothetical vendor owns the property. So it's my submission that there's no strong identification of the hypothetical vendor with the purchaser. In that sense, the standing in the shoes theory is not to be pushed to any remarkable extreme. One simply hypothesizes that the hypothetical vendor owns the property, but he is in fact anonymous, and that is again what Lord Hoffman says in the Fox case.
One assumes that he's willing to sell. I mean, Lord Hoffman says you make that assumption, and the vendor is willing to purchase, but you just make those assumptions in order to give life to the transaction you're trying to contemplate.
Oh, yes, precisely so. And when one looks at the other side, it's the same. One needs to hypothesize a hypothetical purchaser who's actually interested in purchasing the property, and who, it follows from that, would be able to be registered as holder of shares that are in question here.
It takes you back to what the property is, isn't it?
Yes, it does. Yes. So that, so far as the hypothetical purchaser is concerned, I would simply remind my lords that the issue in Lionel, which admittedly has been somewhat superseded by statutory provision in relation to information deemed to be available, nonetheless, the issue in Lionel at the time was what information can we deem the hypothetical purchaser to have. And one can see from the discussion there that it was thought inappropriate to approach the matter on the basis that the hypothetical purchaser might be a director with certain information or might not be, and therefore might not have it. But all of that goes to show that one isn't actually making any assumptions about his personal characteristics. One is simply asking for a hypothetical purchaser with an interest in purchasing the property and becoming registered as a holder if we're talking about share.
Can you remind me of the particular subsection that develops the Lionel point It's in the Capital Gains Tax Act, or the
Yes, it's section 273, subsection 3.
2733, thank you.
And it simply is a deeming provision about what information is deemed to be available to purchasers.
Yes.
Minister, just push the button for this.
Oh, Lord, yes, I'm obliged. I'm not used to microphones. Well, the final general proposition I have, which I think is the one that Lord Roger was touching on a moment ago, is that it's my submission that the actual seller's rights under a collateral agreement do not come into the valuation for these purposes unless, because they are rights attaching to or embedded in the shares, they affect the sum that a purchaser in the open market might reasonably be expected to pay.
That again, please. Attached to or embedded in or something.
Yes, they do not affect the valuation unless, because they are rights attaching to or embedded in the shares, they affect the sum that a purchaser in the open market might reasonably be expected to pay.
And you put in there, because they are rights embedded in
the shares.
In the shares. What does that mean?
Simply that they are properly to be treated as part of the property to be valued. So it links up with my first proposition. We identify the property to be valued, and it's my submission that the property to be valued will only include rights under a collateral agreement if they are, for example, as would be the case in relation to an agreement that created rights that were enforceable by any holder of the shares, could be said to be real in that sense as opposed to personal.
So can I just pursue this a little? I mean, either they could be class rights identified in the articles, which would actually be inherent in the asset itself, or they could be in a collateral agreement which made it clear that these were transmissible to purchasers.
Yes.
But if they're not assignable from the vendor, will they always fall outside what is to be valued?
I'm not sure if I can go that far, my lord. If they're not assignable, and the reason for that is because they are personal to the current holder, then they would, in my submission, always fall outside the valuation because they simply would be of no interest to a purchaser. The reason I would hesitate to say that non-assignability is conclusive is that one might, as in Crossman's case, say that a restriction on transfer has to be left out of account in trying to value the shares. Similarly, I suppose one might say that a restriction on assignation would need to be left out of account. But in my submission, what really matters is if one can see that the rights are actually personal to the current holder, and therefore they're not rights that could be enjoyed by anybody else. Clearly, the fact that they're non-assignable is a reflection of that, but as I would submit, it's the fact that they're not intrinsic to the shares, but simply additional personal rights that is what speaks against their being included as part of the property to be valued under this exercise.
Well, you wanted us to look at Crossman, but as I understood it, Crossman was making the point that if you gave full weight to the restriction in that that was a private company, a restriction on transfer, you wouldn't have any value attached to the shares at all.
Yes.
And to get over that problem, in order to find something that actually would be valuable for purposes of estate duty, you had to assume that these were shares that were transmitting, but they carried with them the restriction.
Yes.
So that for that purpose, and that was good enough, just the one transaction that was being assumed hypothetically for that purpose, one lifted the restriction but put it on again in the hands of the purchaser.
Well, yes.
That's a rather special situation, I would have thought.
Yes, but in my submission, it does show the very limited scope of the Crossman doctrine. As my lord has just explained, it's not there in order to achieve any kind of identification in any strong sense between the seller and the buyer. All it's there to do, as my lord has explained, is to leave, for purposes of machinery, to leave out of account a particular restriction which would have the effect that the property was actually valueless. As I think the Lord Chancellor said in the case, that the choice is quite a stark one. If one assumes that the shares cannot be transferred, and then the Estate Duty Act could not bite at all.
But we do have to be quite careful, I think, about assuming that if something's personal, it can't be embedded, and if it's in the 1930s, and this is going back quite a long time. In the 1930s, when estate duty was much more primitive, a very common dodge was for the owner of a large estate to sell it to an estate company, and he would be under the articles. It was all embedded in the articles. He would be governing director for life, and he would have governing director's shares, which entitled him to the entire income of the property during his lifetime, and then the share became valueless on his death. That was all embedded in the articles, yes. But it was evidently regarded that the shares were indeed valueless at his death, and special legislation was brought in the Finance Act 1940 in order to stop that particular device. So there are cases, even if they're very exceptional ones, where very personal rights are embedded in the articles. And what do you have any comment on that?
Well, I think my only comment would be that if they are very personal rights, then for the purpose of identifying a property to be valued, then just applying the ordinary capital gains tax and estate duty authorities that we've looked at, they ought to be left out of account because they do not form part of the property that would be of interest to a hypothetical purchaser.
Even though they're in the articles? Even though they are in the articles?
My Lord, yes, I think that must be so, in the sense that the articles obviously are one form of agreement. A collateral agreement is a different form. But if the rights generated under either kind of agreement are intrinsically personal rather than anything that could be enjoyed by anybody else, then it's difficult to see why that should come into the valuation for the purposes of this exercise. I think one of the new authorities that was produced yesterday, I think, gave or possibly one of the textbooks, gave the example of a provision in articles where a named person should be entitled to be company solicitor for the company. And one can see that may be in articles, but it is nonetheless inherently, or perhaps that's the wrong word, it is essentially, it's a personal matter, and it's difficult to see how it could possibly be of value to anybody other than the named individual.
Well, it had nothing to do with being a shareholder, did it? I mean, I think he started off as the solicitor to the company and not a shareholder, and he later acquired some shares. But the bit in the articles had nothing to do with his status as a shareholder.
Yes. Lord, I think that may well be the key distinction to be taken, that one's looking to see, because we're concerned with whether somebody would pay value for a particular aspect of these shares, one's concerned to know whether these rights actually go with the shares, and that's to say that they can be enjoyed by a shareholder, or whether they're actually rights that simply go with a particular individual who has the shares for the time being. Lords, in relation to Crossman, I simply wanted to mention 2 or 3 short passages which were not mentioned yesterday.
This is volume 2, tab 13.
It's volume 2, my Lord, yes. And it's tab 13. And I do this by way of supporting the point I've just made, that what we're actually interested in is the rights that make up the value of the shares. And the first passage is on page 41 in the speech of the Lord Chancellor. about 6 or 7 lines from the bottom of the page, His Lordship explains that the right to receive the price fixed by the articles in the event of a sale to existing shareholders is only one of the elements which went to make up the value of the shares. So what His Lordship is suggesting there is that one cannot say the shares are valueless because of the restriction on transfer. One has to think about all the other rights that go up to make up their value. But the significance is that His Lordship is there thinking about what actually are the rights that make up the value of these shares. And in my submission, given that Crossman is the basis for the subsequent line of authority, the foundation for Crossman is that we're looking to see what rights are inherent in the shares themselves.
What does that mean? How's the hypothetical seller, what rights has he got?
Well, one starts with the position that he has the same property to sell.
And has he got the rights? Can he operate? Is he in as good a position as Mr. Gibson?
Well, I think one would assume that he must have what Mr. Gibson has as a hypothetical seller. Then the question is...
Somehow or other, Mr. Gibson's rights have got transferred to this hypothetical seller.
Yeah, in my submission, it's clear from the authorities, if one approaches it from the angle of the hypothetical purchaser, that one is interested in what he actually will pay for, because he needs to know what can be transferred to him rather than remain behind with the vendor. So if one then goes back to the vendor's end of the line, I think one still faces the question that, in essence, it doesn't make much difference whether one says the hypothetical vendor is endowed with these personal rights or not, because the test is what price will the property fetch on the open market. And that is, as the authorities explain, to be measured by what the purchaser will pay.
Ultimately, it's the saleability of the commodity, isn't it? And the rights of the vendor can't enhance that or diminish it. It's really what the purchaser is prepared to pay.
Lord, yes, I would respectfully agree with that. And indeed, the Duke of Buccleuch's case, all of their lordships make the point that for applying the statutory wording, very similar to our own wording here, the concern is with what the purchaser will pay. And so they point out that there's a certain unfairness, because that formula means that the seller's expenses are simply disregarded. Mm. But they do make the point that the interest is in the position of the purchaser and what he will pay for whatever he's acquiring.
Your starting point, I think, first proposition was that the first step is to identify the property to be valued. Yes. And it just occurred to me that in a sense begs the question here. I mean, obviously in Crossman, what they were valuing were shares, and there wasn't any doubt, I think, in Crossman as to what the asset was. And the question then was, well, what does that asset embrace within it? And you've got the various rights which go with the shares,
yes,
and which no doubt are transmissible on a sale of those things. But in this case, the argument is that one's got to be rather careful in identifying exactly what it is that one's valuing. And
yes, my lord, I do accept that the question that arises here did not need to be confronted directly in Crossman's case. What I think, perhaps the only other point I can usefully make here is that if one goes then to the Fox case, to Lord Hoffman's case, his understanding of the Crossman case is evidently to the same effect as what I've just put forward, that one needs to look at the rights that are inherent in the shares, or inherent in the property, I'm sorry. And he does that in a context where there is actually more than one item of property involved. If I could simply give my lords the reference, this is Volume 3, Tab 20. And it's at 371, letter H. just above letter J, in fact, the 2 lines above where Crossman appears in the left hand, it says, His Lordship says, the question is what a purchaser in the open market would have paid to enjoy whatever rights attached to the property at the relevant date. See Crossman. And then the hypothesis must be applied to the property as it actually existed, and so forth. And the significance of that, my Lord, is that His Lordship then goes on using that understanding of Crossman to consider how it should apply where, as in his case, one has on the one hand a lease and on the other hand an interest in a partnership relating to the lease. So that in my submission, while the facts are of course quite distinct from these facts, in my submission what one has is a clear instance where, for the purposes of trying to establish where there is more than one item of property involved, which rights come into the valuation, the key question is to identify the particular property with the rights that are attached to it. So again, while I accept it doesn't perhaps address this position head on, nonetheless, it does I would support the view that when we're looking to value what a purchaser would give for a particular property, rights are to be taken into account so far as they are inherent in the property, and therefore a purchaser would be interested in paying something for them.
But I mean, on your analysis, are these 14,000 and odd shares just, they might as well be any other 14,000 and odd shares?
Yes, my Lord. They are the same as any other shares. They're subject to the same articles. And indeed, as my Lords will have seen, Lord Kingarth said precisely that all the shares are the same. There is no special class of shares, as my Lords know.
But the restrictions on his disposal, they are taken into account. Or his right to dispose.
I'm not sure that I follow.
Are they taken into account? I mean, there might be other shares which did not have that restriction.
Yes.
I mean, is the restriction, does one take account of the restriction on disposal?
Well, on the authority of Crossman, one simply needs to be able to apply the statutory valuation to the property in question. So if there's a restriction that says this property can never go to anybody else, then that has to be left aside in order to carry out the valuation. But in my submission, that's as far as Crossman goes.
But what you're valuing is a share subject to that restriction.
Yes, that's right, yes.
And that restriction would come in this occasion from the agreement, wouldn't it? So you go that far into the agreement.
All the shares are subject to transfer restrictions under the articles, as we've seen. So I think in essence what one would be doing is saying leave aside these transfer restrictions, whether they're in the agreement, whether they're in the articles. We simply need to know if there were no such restriction, what would a purchaser pay for it?
Is that because one's dealing with an actual transaction here where, although individually each shareholder was under a restriction on transferring the articles, it had been agreed that the entire share capital of the company would be sold on to Jewson? Is that right? The transaction with Jewson couldn't take place if the restrictions were enforced.
I think there might be some assistance in Lord Hoffman's statement in the Fox case. The property must be assumed to have been capable of sale in the open market, even if in fact it was inherently unassignable.
My Lord, yes, I'm obliged to, my Lord.
It's at page 371, letter H.
But in this case, Mr. Gibson had an advantage over all the other shareholders, didn't he?
Yes.
And the question, really, the whole point is whether that advantage which he had was something that that affects market value.
Yes, exactly. No, yes. My submission is that it doesn't, because one simply looks to see what rights do these shares carry. His shares are no different from the other shares. He does, of course, have the benefit of this personal agreement. But in my submission, for the reasons I'll develop in a moment, that is not of interest to a purchaser and therefore would not result in a higher price being paid for his shares.
But does the warranty, 7.1, does that enter into the thing? Which is the one about, other than pursuant to provisions, he will not sell, transfer, and so on.
Well, in my submission, none of those are really of assistance when one is trying to determine the overall question. Are these rights personal rights, or are they rights that attach to a share such that they should be part of the valuation? So it would be my submission that it doesn't, in fact, enter into it, because it doesn't really answer the question that has to be asked. If I could perhaps simply deal with a few features of the agreement, since we've arrived at that point. There are, I would say, three important features about it. Probably the last of them is the most important. The first one to note is that it binds the parties who entered into it, but it is not binding on all the shareholders. We know that it was only executed by 83.8% of them. And indeed, it does contemplate that others might not be content with it.
I wasn't quite sure how strong a point that was, bearing in mind that the agreement itself was preceded by a special resolution, which we find at 109. Do we? Sorry, the minutes of the Extraordinary General Meeting, 167.
Well, I think I would accept it's not a crucial point. It's worth noting insofar as there's some discussion at least in textbooks, if not authority, about the significance of an agreement entered into by all shareholders. So to the extent that that's significant, it's simply worth being aware that this is not in that category, because it's not been entered into by all shareholders.
Well, that's true, but 167, the special resolution, which is to be taken to have been assented to by everybody, was that Mr. Gibson and certain shareholders, it approves the entry into, by the company, and Mr. Gibson and certain shareholders of the agreement in the form NX. And I wasn't absolutely clear in my mind exactly what is going on here. The company is being authorised to do this because there are things that bind the company in the agreement.
Yes.
And therefore it has to have authority to do that.
Oh, yes.
But is there more in the resolution than just that it still has the agreement still has the characteristic that you say it bears, which is that not all shareholders are party to it?
Well, yes, that would be my submission. The company undertakes this by entering into the resolution, but one can't draw anything further from that in relation to the particular shareholders.
Were there sort of three types of shareholders in terms of the amount of money they were going to get on the sale of their shares? Mr. Gibson, who was going to get more than the average,
Yeah.
the 80-odd% who were agreed under the shareholders' agreement that he should get more and were therefore going to get less.
Yes.
And then the people who didn't agree, who presumably got the actual average.
Well, yes, I think that's right. Yes. So,
well, apparently that's not common ground.
Mr. Sherry, are you suggesting there's some... we can't make that assumption. What are they?
That was the amount that Mr. Gibson got and everybody else was pro rata.
Mr. Gibson got his amount under the agreement. Everybody else was pro rata.
That was my instruction.
I'm sorry, I've just checked the position and it is in fact common ground. I apologise,
I
my lord.
So they got less than they would have got, even though they didn't agree that he should get more.
That's right, my lord, yes.
But in to say they were pro rata.
Yes.
Yeah. Yes, I see, thank you.
The second, and I would submit more significant point, is that his shares were not created a separate class of share. And so his rights under the agreement were not embodied in a class of shares of which he was, for the time being, the owner.
I mean, you say by definition, if it's a special class of share, then whoever gets it likewise gets whatever's special about it.
Subject only to, if there were particular, clearly personal matters, such as the company solicitor point that we discussed, then I think one would have to make an exception for that. But otherwise, if one has shares of a particular class that enjoy particular rights, then in my submission, those rights are rights for which a hypothetical purchaser would pay.
I suppose you could have preference shares which conferred a preference only on a given individual, so that the preference flies off if the shares are sold.
Yes.
That would be an example, would it, of something where, although it's a class, the market value wouldn't be affected, are you saying, by the preference that individual had? It's difficult to contemplate. I mean, his preference would be in over the income of the company, I suppose.
Yes. Yes. In my submission for these purposes, the key is really always to bear in mind what Crossman's case established, so that one has to make the machinery fit, as it was put by Lord Russell in an earlier case. And that means that one has to ignore things that will make the property, as Lord Kerr said, inherently unassignable or non-transferable. But beyond that, one has to value what is there, if on a proper analysis it is part of the property. But if, as I submit in this case, on that proper analysis it is no part of the property, it's simply rights that this particular individual was able to exercise, then that does not come into the valuation.
And the word attach, which is used in Crossman, is a guide to what one should take into account then, is it?
Lord, yes.
What attaches to the shares?
Yes. And so far as the facts of this present case are concerned, on this point it's perhaps worth noting that, as my lords know, the company, at the very time of entering this agreement, adopted new articles of association. But for some reason, the decision was taken that these particular rights given to Mr. Gibson should not feature in the articles of association, but should be in the separate subscribers' agreement.
Would it have made any difference if they had been?
I think, my lord, probably not. On the analysis, if they're personal rights, then they would not be of interest to anybody else acquiring the
How do you know if
shares.
they're personal? I mean, what's the touchstone by which you decide?
I think one could only analyse the particular circumstances and facts of this agreement in order to take a view on that.
Well, I mean, the 6.1 acknowledges that Mr. Gibson's become executive director and so on. I mean, that
Yes.
is clearly it's only him who's to get that position.
Yes. My lords, in relation to the question of personal rights, the main points are summarised in the respondent's case in paragraph 7. And as my lord in the chair has pointed out, one of those main points is that the rights are conferred on Mr. Gibson on a particular basis, that it's acknowledged and accepted that he's to become an executive director of the company. I could simply remind the lords of the essential points laid out in paragraph 7 of the case. Which is on the second page. It's pointed out firstly in one of the recitals that certain undertakings were given to Mr. Gibson secondly, reference is made to the composite transaction in which those rights were conferred on him, and right at the bottom of the page, he was appointed a director of the company and the subsidiary. Then the third point is one I've made already. The fourth point simply summarises the circumstances in which Mr. Gibson would receive consideration for his shares. And paragraph 5, my Lord and the Chair has already drawn attention to, that it was acknowledged and accepted that he was to become an executive director of the subsidiary company and shareholder on terms such that he would be entitled to an agreed extra payment. And 6.6 points out that provided the undertakings given by the other shareholders were to apply from the date of the subscription agreement until such time as he and or his executors or representatives ceased to hold any of his shares. And as we've seen, the rights were unassignable. The essence of it in my submission is that when one looks at those, when one bears in mind also that a draft of his service agreement was attached to the subscriber's agreement, then the proper conclusion to be drawn is that these are personal rights that Mr. Gibson had against certain other people, rather than that they are rights that are attached to the shares. They are rights that are conferred on him expressly in relation to his employment. And as one can see from the reference to net asset value and target net asset value, the underlying notion is that any premium he derives from selling these shares is derived from the performance he has provided as an employee and director of the company. That is the means by which the shares will increase in value.
In referring to target net asset value, we're referring to what we see at page 181 in the agreement, or is it appears somewhere else, does it?
No, I was thinking really of 186, that it's acknowledged, this is in paragraph clause 6.1, that it's acknowledged and accepted that if by reason of his efforts as an executive director certain results follow, he will in certain circumstances be entitled to an agreed extra payment. So what I take from it in essence is that on a reading of the agreement in context, there are so many references that are explicable only by seeking to reward this particular employee for what he has done for the company. But those are not to be regarded as rights for which a hypothetical purchaser would give value.
Can you just explain, going back to a point which I think Lord Brown really drew out and I hadn't appreciated before, that those who are not within the definition of shareholders at page 170 are affected by what we see at clause 6.1.
Yes.
And yet they're not parties to the agreement. Supposing I was one of these people, the residue of 12% or whatever it is of the shares, I would say, well, I want my full value, please.
Yes.
How's that to be met?
I think that's dealt with, my Lord, under, from memory, clause 3.7, which requires, I'm sorry, I should just check this. Yes. Yes, 3.7 on page 180. So one can see there that it relates to persons who are equity shareholders at the date of the agreement, but who are not parties to the agreement.
Yes.
Then there's provision for steps to be taken in order, broadly speaking, to allow the transaction to be followed through.
Oh, I see.
And one has essentially the same provision in clause 4.4 on 2 pages later.
Yes.
Do we happen to know who the trustees of the NYT pension scheme are? Are they individuals who are named as individuals in the sale agreement, or what happened to them? Page 134, we see that the trustees listed as shareholders who joined in the subscription agreement. And at page 255, we get the Schedule 1 to the sale agreement.
Well, I have to say at the moment I'm not able to address that. I'll seek to do so later.
Yeah, but I mean it's a minor point of fact. It'd be quite interesting to know.
Yes. Well, I'll try and have that checked and come back to my lord.
Page 192. It looks as if someone called D. Cook signed for the trustees.
Yes. Well, Lord, yes, I'll come back to that when I'm able to. Lords, I should say a little about the points that were made this morning in relation to certain company law authority, and why it is maintained by the appellants that the particular rights that Mr. Gibson had under the subscribers' agreement should be treated as attaching to the shares. First of all, I would make the point that with the exception of the O'Neill and Phillips case, which appears in the appellant's written case, none of what is said about the terms of issue and so forth binding in such a way as to create rights attaching to the shares has ever been foreshadowed until this morning, so far as I'm concerned. And so it's not made it particularly easy to deal with. However, dealing with it so far as I can, what I would say is this in relation to the particular company law cases relied upon. Firstly, O'Neill and Phillips, which is in the bundle at 23, which is the unfair prejudice case. My submission is that that is authority only for the proposition that in a quasi-partnership company, when the court is considering whether a member has suffered unfair prejudice, it may take into account not just the company's articles, but also any collateral agreements between the members about how the affairs of the company are to be conducted. And that is all that case is about. Now, the appellants seek to take from it the proposition that that means that the hypothetical purchaser would pay more than otherwise. In my submission, the case is being taken totally out of context. And when the issue is one, as it is here, of determining whether a hypothetical purchaser, who by definition has no pre-existing relationship with the hypothetical vendor, when the question is whether he would give any value for rights contained in a separate agreement, this case has nothing, offers no assistance. It's simply on a quite separate point. The second and newer line that has been developed to some extent this morning is to the effect that the terms of issue of shares come somehow to be to create rights that are inherent in the shares. Now, as I've said, since this has only just arisen, I certainly couldn't claim to have researched the area exhaustively. So the points I would make are these. Firstly, as was recognised by my learned friend yesterday, there is no authority on this question. Secondly, the various excerpts from the textbooks that have been provided in the extra bundle of authorities do not appear to support clearly any such contention. I don't know if it would be of assistance for my lords to look at them, but or I could simply give my lords a sentence or two about each of the
So
texts.
I glanced them last night, and I say I didn't find anything absolutely on the point.
No.
It may depend a bit on what you mean by terms of issue.
Yes. It may not help to look at them, my lord. I think that the main points I would take are that if one looks at these authorities, they don't appear to be confronting the sort of situation with which we're concerned. Specifically, in some of them, mention is made of prospectuses. So the notion seems to be that if one issues a prospectus encouraging people to subscribe for shares, then for certain purposes that may be it may be necessary to take that into account in considering what rights the shares have. But what one doesn't find from the discussion is the conclusion that the rights are actually inherent in the shares. They might simply, for example, if there were a breach of an undertaking given in a prospectus, they might simply provide a remedy. But there is actually no thorough discussion in any of these texts that makes it at all clear that the court, without creating new law, would be able to say that the terms of issue, in this instance the subscribers' agreement, is simply to be read as creating rights that are equivalent to rights under the Articles.
The point that came out of these references, and I don't think we need to look at them in any detail, is that you can create class rights by a shareholders' agreement outside the Articles, which you accept.
Yes, it's yes. I mean, I do accept it's possible. Well, for example, some of the textbooks refer to a unanimous agreement that creates shareholders' rights. It doesn't, I think, answer the question whether, for the purposes of the valuation exercise here, the rights are to be taken into account. So one's still left with that question.
But if you pursue that line of thought, I suppose what's in a prospectus, which everybody accepts and is the basis on which everybody subscribes, you could say that could be evidence as to what the shareholders agree amongst themselves, and one could get the prospectus in that way.
Yes, I suppose that may be more. I think the...
Yeah, I mean, I suppose you might say that even if you could create them by the terms of issue, you say here the terms are personal to Mr. Gibson, and therefore not, even that they wouldn't apply to anybody who held the shares. That's
Lord, yes, that's the essence of my position. I could probably have put it more briefly, but yes, that is precisely my submission. I think if I could say just a couple of words about the two cases that are in the new bundle that touch on this point. The first one is the tab 2 of that bundle, the Cumbrian newspapers case. In my submission, it is important to note that in that case, where the particular rights in issue were as one sees on the first page, just at letter G, as part of the agreement under which the shares were issued, rights were granted to the plaintiff in respect of unissued shares and the right to appoint a director. So we can see the particular concern there is with the management of the company. The plaintiff's position in the company, as it were, was to be secured by reason of his being entitled to appoint a director and having say in the issue of new shares. So the whole intention was to protect him in his capacity as a member of the company and in relation to the governance of the company. And Mr. Justice Scott deals with, he creates various categories of rights, which he discusses on pages 15 and 16.
Yeah. It's the third category at the bottom of page 16 that he identifies here. Is that
That's
right?
my submission, my lord, yes.
And
yes.
we see he describes it. It covers rights or benefits that, though not attached to any particular shares, when they're nevertheless conferred on the beneficiary in the capacity of a member or shareholder of the company.
My lord, I'm sorry, I think I agreed too readily to that. My submission is in relation to Mr. Gibson's shares, that it's the second category that applies.
Sorry, I beg your pardon. No, in Cumbrian, it was the
I
point I was
apologise,
making
yes,
was
yes,
I quite see the distinction.
Yeah.
But in Cumbrian, they were dealing with the third category, which is
Yes.
developed on page 17.
Yes.
And you say, well, as I follow, that the second category is the one that would apply here.
Yes. So it all comes down again to Lord Roger's point that my submission is these are rights personal to Mr. Gibson, and therefore one doesn't get where one needs to get by relying on this authority. And the Harman case in the following tab is essentially to the same effect. The question again is, were the rights conferred on the member in his capacity as such or in some other capacity?
And that was a case where, in Harman, all the shareholders had signed the agreement.
Yes. Lord, yes, that's right. And it is a rather special case also in that, as my lords will have seen, it's about section 371 of the Companies Act, which is quoted at the bottom of page 676. And it's concerned with circumstances in which it's impracticable to call a meeting of the company, so that the court is empowered to order such a meeting to be called. But all of this is in the context that where certain rights have been given to certain individuals, and it seems that there's a general unfairness about the way in which they're being treated, the court can seek to address that. But it doesn't really assist when one's considering rights of the nature that we have in this agreement, which in my submission are not conferred on Mr. Gibson in his capacity as a member, but for personal reasons. So, my lord, summing up so far, my submission is that these shares are identical with all the other ordinary shares. It's not to be assumed on the basis of the authorities discussed that the hypothetical purchaser steps into Mr. Gibson's shoes in any strong sense or becomes identified with him, because if that were so, the vendor would have ceased to be hypothetical. But all that is assumed is that in line with Crossman and Lionel, the purchaser can purchase and hold the shares subject to the restrictions which do in fact affect them, and with the rights that are attached to them.
These are the restrictions under the articles you're talking about?
Lord, yes. And so it's for the reasons I've set out in describing these rights as personal that it's my submission that when one asks the question, do Mr. Gibson's rights under this agreement affect the price the hypothetical purchaser would pay, the answer is no. Because they're specific and personal to him. They have no value to the purchaser, and therefore would not affect the price the purchaser would pay. And therefore his shares are simply not worth more to the purchaser than any other shares.
And is it your position that the relationship which obviously he has under the agreement with the other shareholders is of no interest to the purchaser in a hypothetical transaction? The point being made that you can't, this is being said against you, you can't ignore the fact that Mr. Gibson had these special rights, and he would therefore insist that he got paid the amount that was due to him under this agreement.
Yes.
Which is all part of the nature of the company that was being acquired. And that had some sort of value which he could insist upon.
Yes. In my submission, that takes one back to the sale agreement. As my lords were looking at this earlier this morning, and in particular clauses 3.2 and 3.4, I think, in relation to what extent one can say that the purchaser in this market was interested in the distribution of the sale proceeds between the various shareholders. And the one point I would make that I think wasn't expressly drawn out in the earlier discussion is that at the end of clause 3.2, it's expressly provided that the purchaser is not bound to inquire as to the distribution of the purchase price. This is page 237 in volume 2 of the appendix. And just the last two lines.
So the consideration in 3.1.1 is, as it were, an undivided consideration.
Yes.
And then it goes to the vendor's solicitors and...
Yes, I think the point being made by my learned friend was in 3.11, the allocation of the consideration is not binding in connection with warranty claims. But equally, we see that the consideration is to be satisfied by way of transfer to the vendor's solicitors. And it's also provided their receipt is a complete discharge to the purchaser, who shall not be obliged to inquire as to the distribution thereof. And indeed, one then sees 3.4 sets out the entitlement of the vendors. But in my submission, it does go to support the proposition that the reality is that in a single transaction of all these shares, the question of the allocation between individual shares is not of interest to the hypothetical purchaser.
So it's entirely res alios acta. It's left entirely for them to sort it out between themselves. And the amount, as far as the purchaser is concerned, the consideration is delivered to the vendor solicitors, and that's it.
Yes. Now, if I've understood it...
Hypothetical purchaser is only buying Mr. Gibson's shares, isn't it?
Yes. And I think this is the point that the appellants raised by suggesting that it's necessary to take account of all the circumstances. My submission is, though, if one takes the case that the hypothetical purchaser is buying only Mr. Gibson's shares and nothing else is happening at all, then clearly we're not in the territory of the agreement where Mr. Gibson would receive the enhancement by reason of sale of 50% of the shares or more, because that, by definition, isn't happening. Only 5% of the shares are being sold. And my submission is that the flaw in the appellant's argument is that while they agree that the sale must take place in the open market, the effect of their approach of saying look only at Mr. Gibson's shares is that we're not looking at a genuinely open market. We're looking at a market for his shares which takes account of agreement by his fellow shareholders to sell their shares at the same time, and so afford him a premium on his shares. And that premium, going back to my Lord Roger's point, is that premium simply doesn't arise if we have the 5% shareholding being sold on its own. No, it's in relation to the conclusion that the personal rights need to be left out of account. My submission is that that's in accordance with well-established principle and valuation practice, which goes back to Jemieson's case in 1905. And I would also simply note in passing that it was recognised in Crossman's case at page 48, and in Lionel's case at page 696, when reconsidering Crossman, it was recognised that it's relevant for the court to have regard to the impact on well-established valuation practice that would result if the appellant's submission were right. Because clearly there's an intrinsic value in legal certainty in interpreting legislation. So I don't seek to place huge weight on this, but in my submission it's a factor that's relevant to support the submission I've been making as to the proper interpretation of Chapter 3D.
Mr. Johnson, I want to try and sort of get some idea of the shape of all this. I want to know what the role of 3D is in the legislation. And what are we trying to do here? We're trying to ensure, aren't we, that something is taxed as income and not because it would be inappropriate to do so as a capital gain. Is that what it's all about?
My Lord, yes, in essence that's it. The idea is that if these securities are issued to an employee in that capacity, then a benefit of that kind is properly to be regarded as a benefit deriving from employment rather than a capital gain, and therefore it's appropriate that it be treated in that way. And so for 3D in particular, if the employee has a security of that kind and is able to sell it for more than market value, then that is a benefit that derives from his employment relationship. And as my learned friend said, it's, I think, common ground that the paradigm example is that of the so-called stop-loss situation, where the employer undertakes to indemnify the employee if the shares go down in value, so that the employee doesn't suffer a loss, but can sell for whatever the agreed price is. So in that sense, the employee would be selling for more than market value because the shares are actually worth less. So that's I think those are the two essential points, that it arises from the employment relationship and therefore it's regarded as properly belonging within income tax. And secondly, that it's a situation, particularly for 3D, where the nature of the benefit is in the ability to sell the share for more than it's actually than its market value actually is.
Now, this additional sum that's payable to him on the sale of his shares, and because that's the deal under the shareholders' agreement, I mean, it's calculated by reference to the increase in value of shares, but you say it's not a capital gain at all. It's simply a sum which he's paid under the shareholders' agreement referable to his employment.
Oh, yes, that's right. And indeed that, as I think is set out in the statement of the statement of case, statement of facts and issues, I'm sorry, that's the reason why the appellant is actually not the individual himself, but the company which will be liable for PAYE in relation to these amounts of employment income. So there's no getting around it. It is a special rule that's designed to seek to tax as part of employment income certain benefits that an employee may derive from his employment. In this case, the ability to sell shares for more than they're actually worth at the time of disposal.
What do you have to say about the point that this should really have been addressed at the beginning and not at the end? I mean, the rights were established at the start, and it was quite clear that entitlement was there all the way through the period of his employment. Well,
the main point I have to say to that is that it's it's quite plain from the language of Chapter 3D that it's not addressing charges to be imposed at the beginning, but rather at the end. It's a charge on a disposal.
That's 446X little a, is it? If the securities are disposed of.
Yes. And indeed the heading of the whole chapter.
Yeah.
So I don't particularly take issue with the generalities of what was said by my learned friend about when certain other things will be taxed. And indeed, as we've seen, some of the chapters in Part 7 are about charges on acquisition, some of which can be deferred or opted out of. But those are all chapters that make it clear they're concerned with acquisition. This one is clearly concerned with disposal. So in my submission, there's simply nothing in the point that there's some general presumption that one taxes at the beginning rather than the end. One can hardly have such a general presumption in the face of clear statutory language.
They're not all at the beginning, are they? I'm looking at page 67, sorry, top of the right-hand page, 8192. In the case of convertibles, the chargeable event is when the conversion takes place.
Yes. Well, that's right. I suppose what would be said is, or perhaps was said, is the heading above Section 437 is tax relief on acquisition, so that one might say that the starting point for that particular chapter is that the tax charge would be applied on acquisition, but as it happens, it's spelled out that the chargeable events are, as we see in Section 439, events of conversion or events related to conversion, just to keep the point brief.
I mean, can you say that it would be absurd to regard the additional amount he gets as a capital gain on his shares, because after all the other shareholders don't get it by definition because they're paying that amount to him?
Well, I think that would be a fair way of putting it. I mean, it reflects the realities, as I submit, of the situation. That his benefit, as we've seen, derives from his employment relationship and because of the quality of the work he's done in improving the company.
He's done a good job. He's raised the overall value of the company, and to some extent they profit from that.
Yes.
But to the additional extent he's profiting because he's done a good job.
Yes. Well, yes, I would agree with that. In relation to the first, some of the questions my lords have just asked me belong, I suppose, more naturally in my own friend's second chapter of argument.
Certainly,
there is obviously a sort of overlap with the first. And essentially the last few points I wish to make about the first head of argument is that on a purposive approach to this legislation, the construction which I advance is the one that accords with the statutory purpose. And indeed this is, I think, set out in the written case, the proposition being that for the purposes of Chapter 3D, one has to leave personal rights out of account.
Where are you in the written case?
Thank you. I'm right about that. I'm not sure, I'm finding difficulty in identifying the precise point, but if I could just make the point very briefly, it is necessary to fulfil the purpose of Chapter 3D.
Is it the end of 17, is it by any chance? I just see that Chapter 3D would have no purpose, which I think
My Lord, yes, I'm obliged. That's what I was thinking of. And indeed, the second last sentence, I think, touches on my Lord Brown's point. This is a personal premium and properly taxed as income. the final sentence, which I'm obliged to, my Lord, is if the personal rights are carried into the notional sale on the open market so as to be reflected in the market value, the personal premium cannot be taxed as income. And one can see that as a matter of arithmetic, given that for some reason the legislation now proceeds in terms of equations. We can see that if all you have to do is take the actual consideration, which is called CD in chapter 446Y, and deduct the market value, you can leave aside the expenses for the time being. But if one has, if the actual consideration and the market value are the same, as they will be if all rights are invariably to be included, then the chapter really doesn't have any target to address, because the actual market price will be the same as the market value.
I think you said it's a sort of emergency stop loss provision, isn't it? It was said on the other side, one which wasn't pre-contracted. It's when the employer suddenly comes in and says, well...
Even there, my Lord, one's left wondering if there would actually be a purpose for the chapter, because as I understand it, from what was said this morning, if the employer were, as it were, after the event, not at the issue of any shares, but after the event to say, the shares have gone down, I'm sorry, I'll make this up to you. My understanding is that can be regarded as a benefit in money or money's worth, and therefore that would be taxed under the earnings provisions. So that if that's right, one's still left struggling to find anything that this chapter can actually do. Whereas I think the appellants say, in fact they do say in 471 of their case, that their case is not within the mischief of the chapter. My submission is that it is, because it is, to all intents and purposes, the same. And it's worth noting, I think, that the material clause here, clause 421 in the agreement, which is the one that triggered the payment of the sums for the various shares, is a clause under which the parties to the agreement undertake to procure that the company or the third-party purchaser will purchase at a certain price. 421, my Lord. I'll just find the page reference.
181.
Yes.
Yes, 181, my Lord, I'm obliged. And the only point I seek to make here is that, as I've just said, what the shareholders to procure is that the company or the purchaser shall purchase the shares. So the one has a clear relationship with the paradigm case of employer and employee, the employer indemnifying the employee against loss in relation to the shares. And in my submission, the feature that's actually common to the two situations is the agreement to purchase the shares from the employee for a price that may be different from market value. And as I've already submitted, if we take into account the personal rights under the subscription agreement as part of the asset to be valued, then we are inevitably going to end up with the actual consideration received as being the same as the market value. The same would be true, going back to the paradigm case, the same would be true in the stop loss situation. If one takes into account the indemnity against a share falling in value as part of its market value, then there will be no distinction to be drawn between the actual sale consideration and the market value. So in short, there's nothing for the chapter to do if the appellant's argument is correct. And I think I've made this point already, and I only touch on it briefly again, that leaving personal rights out of account is in accordance with long-established valuation practice. So that's actually what people would expect to be done. And we can find that quite clearly spelled out in Appendix 2, pages 375 to 376, which is a note that my learned friend prepared discussing long-established, well, what is I think referred to as perceived wisdom, but presumably meant to be received wisdom.
What's this piece of paper?
It seemed simply to be some advice that was, I'm not entirely sure why it's in the bundle at all, my lord, but for what it's worth, I would suggest that it's quite a helpful account of the received practice in valuation and how one treats personal rights. I can't go any further than that, of course.
It's not clear who's speaking at which point.
No, I don't really seek to make much of it, other than it's quite a helpful summary of how it's understood that the law works. It does bring me to a point which I should touch on, I think, before leaving this chapter of the argument, about the so-called frequently asked questions. And
yes.
I accept on behalf of the revenue that the answers to the questions and the answers taken together are not clear and not accurate, and I cannot shrink from that. They simply don't spell out enough to provide what one could regard as accurate or complete information about the treatment of the sort of transactions discussed.
Well, at first sight, they seem very clear. That's the problem. Very simple.
But very wrong.
I think, but if I may take the second question first, the question is, will the revenue apply market value consistently? I would submit I'm not trying to quibble, I should make it clear, it's accepted this is not correct. But the answer is actually, I would submit, correct, that the market value will be applied consistently, because the market value test is the test under the capital gains tax legislation. What is applied differently according to the purpose of each chapter is the property that has to be valued. So that, without taking a quibbling or debating point, in my submission the answer is actually correct, but I think I would have to say, seen against the rather long, convoluted question, it's probably liable to mislead. And in relation to the first question, I think the only point I would make is that a cross-reference is made to Chapter 2, to a question 2S, which is a question relating to Chapter 2, apparently. And my lords have seen that. The only point one can make is that, as my lords know, Chapter 2 is about restrictions. So that the answer to the question may well have been intended by the person writing it to refer to restricted securities and not more. However, that intention doesn't seem to have been accurately realised. So far as the significance of such guidance is concerned, my lords have seen the case law. In my submission, there's not a great deal of significance to be attached to it. And the only other thing I think I can usefully say is that the guidance was withdrawn in 2005. It's thought to be late 2005. And as my lords heard, it was superseded by a manual dealing with employment-related securities. So, my lords, concluding on the first chapter of argument, my submission is that what we have here is clearly an employment incentive. These shares were bought for £50,000 and sold for £1.45 million. A 5% shareholding was translated into receiving a third of the increase in value of the shares, of the business rather. And of course, no doubt that was in recognition of valuable services provided. But it's precisely for that reason, since the services were provided in the capacity of employee, that these properly fall to be taxed under Chapter 3D. So, in my submission, when one has regard to the language of Chapter 3D, to the purpose, and to established valuation practice that builds on the estate duty cases and beyond, the correct analysis of Chapter 3D is that personal rights do not come into the valuation, because the property that is actually being valued is the shares without such rights.
As I understood it, Mr. Sherry was relying in his submissions partly on the questions and answers, and you say they were wrong. But he was also relying, and he spent quite a lot of time developing this, on trying to show us that in some of 2, 3A, 3B and 3C, rights which were personal and collateral did seem on the text of some of those sections that they were being taken into account in market value. Are you going to say anything about that?
Well, Lord, yes, I'm
You are
move on to
coming
that immediately, if I may.
This is really chapter 2, is it, if you're...
Yes,
Right.
and indeed, as my Lord Walker says...
I see. Well,
Yes. I don't know if my Lords would wish me to address anything under Chapter 1 before I move on. I think I probably...
I think if you don't, just for ease of understanding, if there's anything else you want to add on Chapter 1, perhaps we could just take that before we go to Chapter 2.
I think perhaps just for completeness, although I don't think much weight has been placed on it, if it's suggested that, well, I think it is suggested that Mr. Gibson received market value for his shares, my submission is simply that the only evidence we have in this case is that the third-party purchaser paid £6 million for the whole share capital. We don't have any evidence as to the value of his shares in particular for the purposes of such a purchase, or that the purchaser was willing to pay more for them. So that all, in fact, we have at the time of the sale in 2003 is an agreement some 4 years earlier about division of the proceeds. And I would submit that that's not a valuation of the shares.
Yeah.
So if one takes account, going back to a point near the beginning of my submission, if one takes account of the commercial reality of this situation, we have a single offer to purchase all the shares. We have no evidence that separate negotiations took place with the individual shareholders. And as I've said before, in my submission, for the reasons mentioned earlier, it's a matter of indifference to the purchaser how the various shareholders benefit from dividing the proceeds of the sale. Well, as that takes me then to the second chapter of argument. And this is the point that Lord Walker just raised with me about other provisions in Part 7. My primary submission on this is that the answer to this case turns on the first argument and not on the second argument. Because the concern is with the meaning of section 446X, rather than with seeking to resolve, in what we gather is the first case dealing with this legislation, seeking to resolve numerous other hypothetical questions relating to other complex provisions in Part 7. And I have a number of quite short points, the general significance of which is intended to be to show that there's very limited common ground between the various chapters in Part 7. And my overall submission is that in answering the question that is before the court, namely whether the personal rights come in or do not come into the valuation, one looks, as one would expect, to the language of the section and to the purpose it is designed to achieve. And it's my submission that when one looks at the various chapters in that way, one can explain why some may take one approach and others another. So the first general point I would make is that in my submission it's not appropriate to seek a very extensive degree of uniformity between the disparate chapters in Part 7. And the 2 points I would say that one can regard as common is that these chapters are, firstly, concerned to charge income tax on value delivered to employees by reason of employment. In this context, through owning employment-related securities. And secondly, that income tax is measured by reference to the capital gains tax definition of market value. Beyond that, in my submission, the differences in approach and treatment are in many ways more striking than the similarities. And so I would, on this at least, agree with the appellants when they say in their case at 7.2 that Part 7 has to be approached with considerable flexibility. So I have a number of more specific points. The first of them is that it's suggested in the appellant's case, this is at 6.2, paragraph Roman numeral 3, it's suggested that there's a degree of common ground in the chapters in Part 7 being concerned with undervalue at the time of acquisition.
This is page 14, is it?
My Lord, it's page 15.
15.
Just before paragraph 6.3, and where it's observed that the premise behind Part 7 is to tax in an appropriate way, and this is directly linked to the extent of undervalue on acquisition.
Yes.
Well, in my submission, if that's intended to be a general proposition, then it doesn't in fact cover several of the chapters. Well, firstly, we've seen that Chapter 3D is concerned with disposal rather than acquisition. And secondly, as I think should have emerged from the discussion about the paradigm case for Chapter 3D being an employer relieving an employee of losses that might otherwise arise from the securities, there's actually no question of an undervalue there at all. There's a loss that is being stopped, but there's no question of there actually being an undervalue. And one can say the same about chapters 3b, 4 and 5. They're not directed at undervalue at the time of acquisition either.
3b.
3b, my Lord, yes. It's securities with artificially enhanced market value is the heading. That's on page 8198. I'm not planning to take my Lords into any detail. Similarly, Chapter 4 is about post-acquisition benefits from securities. So that's not about undervalue on acquisition either. And Chapter 5 is about options. And it's worth noting that they all employ the same definition of market value by reference to the provision in the 1992 Act. So that supposed common ground is, in my submission, not actually present. This is not a chapter, a part of an Act that is directed at a common issue of undervalue.
Would that be a convenient point to break?
Lord, yes.
Well, we look forward to seeing you at 2 o'clock.
fairly well through, actually.